the Family Matters show. I'm Benjamin Bryant, a partner at Bryant McKinnon Lawyers here in Coffs Harbour, and today I'm joined with family lawyer extraordinaire, Gemma on my team, Gemma Rowe. Welcome.
Hello. Thank you.
Can you explain more about how child support works? My husband is only paying me $50 per week, even though I only have a very small weekly income and look after the children on my own. How is it possible that they allow a father to only give that much support to his child? Is there something I could do?
Like you say, Ben, we get a lot of questions about child support. It seems to be an issue that really confuses parents, and for some parents, they really like having the child support arrangement in place, or the sort of child support agency taking care of that side of things, and others absolutely hate it.
Yeah.
They don't like it being controlled in the way that it comes out. So basically, it's a child support assessment is a formula based on each parent's income, the time each parent has with the child or children, and the amount of dependence and their expenses and things like that. It's just a calculation, and obviously sometimes people are happy with what gets spat out. And other people are not happy. Obviously this person is not happy with the assessment. Perhaps they think that dad works enough and gets enough income to justify spending more money on his child. Maybe this person feels like because they pay for soccer and they pay for school and they pay for all the food and all these extra expenses that's not taken into consideration, and it's unfair. It's a really tough one because it's not something we can really deal with. I mean, there is an option to opt out of using the child support agency. You can enter into a child support agreement.
Okay. Binding or limited?
Yes, that's not always going to work for everybody. For example, if you're receiving a parenting payment, Centrelink may not allow you to opt out of that using the child support agency because, of course, basically you're saying the taxpayer should have to pay you extra rather than the father or the mother. Yeah. So it's a very, very, very tough one there, and definitely depends on each person's separate circumstances as to whether that's going to be appropriate. But certainly for some clients, they do make child support agreements and they feel like that's much more fair for them, as in dad will pay the school fees, dad will pay the private health insurance, mum will pay this or that, and that's to be in lieu of child support. So
the child support website is a really great tool on there, the online calculator, and I refer people to on a weekly basis. You can get notional assessments, or you can just type in your details, type in the care arrangements, income, dependence, and things like that into an online. And it's not an assessment, it's not a formal assessment, but it gives you an idea, and it really again arms parents to be able to make decisions as to whether to go ahead with the child support assessment, whether they think it's fair in the circumstances, or whether what you were suggesting they have their own arrangement. Because some people, certainly around time of separation as well, some people come up with their own. There's no lawyers, there's no agreements, there's no child support formally assessed. They come up with their own arrangement. They say, I'll pay half your rent or something, or I'll continue paying for blah, 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 blah. And that continues on until something happens, until someone repartners, or until a house needs to be sold and there's a family law property settlement or something like that. And so that's when the issue really arises. And why lawyers, why people I think get frustrated is that you're seeing lawyers, about your family law matter. You're seeking, perhaps parenting orders from the court. Who does the child live with? Who has parental responsibility? Who spends time with the children and when? And that's all under the Family Law Act, and they're all under the scheme of parenting orders, and that's what most matters before the Family Law Act, or in the Family Court or the Federal Circuit Court. That's what most of those orders are about. Child support is something different. And just to confuse people, if you look into the Family Law Act, they do talk about, it's not called child support, it's called child maintenance. There is provisions in the Family Law Act, if you look at it today, about child maintenance, but for the last 20 years they've basically been inoperative.
Mm.
The Family Law Act and lawyers really going to get involved in really special circumstances where the registrar of the Child Support Agency or Department of Human Services refuses to make a decision because the matter is so complex, or it might be circumstances where there's child maintenance provision in relation to children that are over 18, whether they have any special needs or some other circumstances which might make it appropriate for financial security, or the other parent, assisting with funding past the age of 18. That's when a court will get involved, okay? Otherwise, the parent's battle is normally rests with the Child Support Agency, and in most circumstances, they're stuck with the assessment. It is what it is. It's not something that the government does lightly. A lot of resources and years went into the new assessment, as they call it. It's a quite complex formula. There are some circumstances, they call them under legislation, it's called special circumstances, whereby a parent can appeal, can ask the registrar to relook at the matter. Okay, so they get the registrar of the agency to have a look at it, and if they won't or can't, then there's further appeal process with a tribunal. But to assist this parent specifically, I did go on and I used our legal research software that we have, which provides a bit of a summary of special circumstances that are relevant when you can ask the registrar to review their decision. And I wanted to read this out. There's 10 of them, and I just wanted to read them out so everyone has the benefit of it, but also so we can give this parent something to go off. It may well be that none of these special circumstances exist for her.
Okay.
But anyway, I thought we'll go through this. So the first one is you can take into account the cost of spending time with or communicating with a child if it is more than 5% of a person's adjusted taxable income. So obviously, spending time with, any costs with that could be supervision, that might be airfares if there's families overseas or something like that, and also there's a reference there to a person's taxable income. If children have special needs, if there were extra costs in caring for, educating or training the child in the way that both parents intended, and we've had some matters in the past, and child support have been very focused or interested in who signed enrolment forms for private education. Okay, if it was a circumstance whereby the child was a public, the public education, and then a parent enrolled, and the other parent kind of acquiesced and said, oh, whatever, then perhaps not. But if it's always been the case, if this child's attending school, then certainly. If the child has an income or an earning capacity, I thought that one was interesting. If a party has provided money, goods or property for the benefit of the child, so again that could be talking about what I said before, when people make their own arrangements, how long that's been going on for. The cost of childcare, a party has out of ordinary necessary expenses unable to support themselves. The assessment does not correctly reflect either party's income, property, financial resource, or their capacity to earn income. So therefore, perhaps there's a disagreement as to how the income, the adjusted income, was assessed. If there's a legal duty to support another person, other dependents in the household that perhaps the assessment itself hasn't accounted for. And the effect of how responsibility to support a resident child, which will significantly reduce their ability to support the supported child, so the paying parent, any dependents that they have on their side. So there's a set of 10 examples which have been noted to be special circumstances. But again, it's not, and people do get frustrated with this. They go and see a family law specialist. They just want this, advice is to cover the field. They want to go to court and seek orders in relation to what they want. The reality is that you can't, the court cannot, the court will not make an order for child support in the same application as parental responsibility or who the child's to live with or spend time with. It just can't happen. The parents, of course, can enter into parenting plans, which is common. A parenting plan is something that's essentially prescribed by the legislation. It's the first port of call in family matters. If it's a parenting matter, and before the parties can litigate, unless they meet an exception, then the parties are required to mediate. In that mediation session, it must be advised by the Family Dispute Resolution. The parties must be advised that a parenting plan is an option for them to enter into. A parenting plan, because it's not registered with the court or it's not enforceable, it's not used. It's not a parenting order per se. It can include anything.
Yeah.
It can include the things. It can include things that are in orders. It can include bedtimes, dietary needs, all sorts of things, and also that they agree to attend the school and pay the school fees, or attend soccer training and pay for ballet lessons. There's a really wide ambit with parenting plans, okay? Whereas, like I said, with parenting orders, it is quite restrictive as what you can ask the court for, even if it's by consent.
Yeah. The problem is with the parenting plans is you need consent.
That's the problem. That's the problem.
So if this person's partner is not willing to pay any extra, that's going to be.
That's right. Liable to pay any extra. And I do know, the question is quite emotive in the sense of, allowing a father to only support you as much. I think it should be, to be fair, noted that, of course, the Family Law Act or in the Child Support Assessment Act doesn't mention mother or father or male or female. It's just what the assessment spat out.
Yes.
If you have any questions along those lines, or any questions at all really for Ian Nesbitt, please send them through. You can email us at familymatters@bryantmckinnon.com.au, or you can send us a message on Facebook. And thank you for being with us.